Now on C-SPAN 3 about the situation in Afghanistan. President Obama to speak around 11 a.m. today in Cushing, Oklahoma. Go to cspan.org for more details. But now, live coverage of the House.
The House will be in session. Prayer will be offered by our chaplain, Father Conroy.
Let us pray. Eternal God, through whom we see what we could be and what we can become, thank you for giving us another day. Send your Spirit upon the members of the People's House to encourage them in their official tasks. Be with them and with all who labor here to serve this great nation and its people. Assure them that whatever their responsibilities, you provide the grace to enable them to be faithful to their duties and the wisdom to be conscious of their obligations and fulfill them with integrity. Remind us all of the dignity of work and teach us to use our talents and abilities in ways that are honorable and just and are of benefit to those we serve. May all that is done this day be for your greater honor and glory. Amen.
The Chair has examined the journal of the last day's proceedings and announces to the House his approval thereof. Pursuant to Clause 1, Rule 1, the journal stands approved. For what purpose does the gentleman from Texas rise?
Mr. Speaker, pursuant to Clause 1, Rule 1, I demand a vote on agreeing to the Speaker's approval of the journal.
Questions on agreeing to the Speaker's approval of the journal? Those in favor indicate by saying aye. Aye. Those opposed, no. Opinion of the Chair, the ayes have it. The ayes have it, and the journal is approved.
Mr. Speaker.
Gentleman from Texas.
I object to the vote on the grounds that a quorum is not present and make the point of order that a quorum is not present.
Pursuant to Clause 8 of Rule 20, further proceedings on this question are postponed. Pledge of allegiance today will be led by the gentleman from Illinois, Mr. Dold.
Please join me in the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Chair will entertain up to 5 one-minute requests on each side. For what purpose does the gentleman from South Carolina rise? Without objection, so ordered.
Mr. Speaker, every American should be given the freedom to make his or her own decisions regarding health care. When the government takeover health care bill was passed, the liberal-controlled Congress took away this right and instead created the Independent Payment Advisory Board, IPAB. This board is comprised of 15 unelected and unaccountable bureaucrats who will be responsible for making major cuts to Medicare, which are likely to lead to waiting list, deferral of service, and denial of care. Today, House Republicans will vote on a bill that will eliminate IPAB and help strengthen our Medicare system for a doctor-patient relationship. Our country cannot afford to spend $1.8 trillion on an unconstitutional government mandate, which the NFIB reveals will destroy 1.6 million jobs. In conclusion, God bless our troops, and we will never forget September 11th and the global war on terrorism.
For what purpose does the gentleman from Pennsylvania seek recognition? And the gentleman is recognized.
Madam Speaker, I rise today in support of repealing IPAB. However, I speak in opposition to tying this repeal to House Resolution 5. This is another act of political theater and disingenuous at best. IPAB relinquishes congressional responsibility to care for our seniors. Passing these decisions off, whether it is to insurance companies or an unelected commission, undermines Congress's ability to represent the needs of our seniors and make decisions on health care policy for Medicare beneficiaries. We must preserve access to quality Medicare while containing costs and replacing the flawed payment system. Simply cutting reimbursements is not the answer. If we truly want to rein in the cost of Medicare and repeal IPAB, we should do it as a stand-alone bill. The Senate has no intention of bringing House Resolution 5 up for a vote. Why then are we wasting our time on legislation that has no chance of becoming law? Americans want their elected leaders working together to find solutions to the problems facing our country, not to be active participants in political theater. I urge my colleagues to have an open and honest debate on Medicare reform by bringing an independent IPAB repeal bill to the floor. I yield back the balance of my time.
For what purpose does the gentleman from Arizona rise?
Madam Speaker, I rise today in support of the legislation we'll vote on shortly. to repeal the Independent Payment Advisory Board created under the Patient Protection and Affordable Care Act. This is something that simply should not have been done. These are unelected board members, 15 of them, appointed by the President, tasked with finding savings and making recommendations. Unfortunately, because of the limitations that what the board can cut, the majority of spending reductions will come from cutting reimbursements for doctors and those who care for Medicare patients. The ultimate result will be fewer options for patients who are driven out of the Medicare system, when doctors are driven out of the Medicare system. We were told when the Affordable Care Act was passed that it would lead to a reduction in premiums. It's done exactly the opposite. This kind of board and these kind of decisions made by unelected officials will simply drive the cost up further. And we cannot afford to do that. My only regret in today's action is that we're not repealing the entire act, and I hope that comes soon. I yield back the balance of my time.
For what purpose does the gentleman from California rise? And the gentleman is recognized.
Madam Speaker, today I rise to speak of the need to protect health care of the American woman. Last week I hosted a women's conference focused on the benefit of Affordable Care Act for women. The historic health care reform is a step in the right direction for the health of mothers, sisters, daughters, and granddaughters. Thanks to affordable health care, a woman can no longer be dropped from insurance coverage when they get sick or become pregnant. 20 million women have already used pre-preventive services offered through health care reform, including mammograms and colonoscopies. Beginning 2014, women will no longer be denied coverage for having pre-existing conditions. The health care law finally ends gender rating, in which women are forced to pay higher premiums than men for the same coverage. American women are the foundation of our families. We must protect the benefit of health care reform and ensure that all women, and I state that all women, have better access to health care. I yield back the balance of my time.
For what purpose does the gentleman from Illinois rise?
I ask unanimous consent to address the House for 1 minute and revise and extend my remarks.
The gentleman is recognized.
Thank you, Madam Speaker. Madam Speaker, our national debt now exceeds $15.5 trillion. I think it's fair to say that Washington has a spending problem. Republicans and Democrats alike have overspent over the years. In the past 4 years, Washington has spent over $5 trillion of taxpayer money that we don't have. The degree of how much this actually means to the American public, I think, is incomprehensible. Most people that I talk to just say that's a heck of a lot of money. I talk about the deficit of $1.5 trillion that we spent this last year, and they say, I just think it's a lot of money. Works out to be about $3.4 million a minute in deficit spending. But if we take 8 zeros off of these numbers to put it in perspective for the American family, I think it gives them a good idea about what their budget would look like. Annual family income would be $22,280. The money the family would spend in a given year would be $37,080. The debt on the credit card, new debt on the credit card, would be $14,800. The outstanding balance, which I think is important, is $155,000. And the total discretionary budget cuts that were put in for 2011 for this family, $398. Madam Speaker, that's what we're facing. We must pass a budget that takes the steps necessary to rein in the out-of-control spending that our country has today. Put ourselves on a path to economic prosperity. We have no other choice.
For what purpose does the gentlelady from Maine seek recognition? Massachusetts. Massachusetts.
The House for 1 minute.
The gentlelady from Massachusetts is recognized.
Madam Speaker, tomorrow marks the 2nd anniversary of the landmark health care reform bill being signed into law by President Obama. Many of the important reforms under the new law benefit women who for years have faced discriminatory practices by insurance companies and borne higher health care costs simply as a result of their gender. Because of the new law, women can no longer be denied coverage or charged more for such pre-existing conditions as breast or cervical cancer, pregnancy, or of all things, being a victim of domestic abuse. Women no longer have to share the cost of critical and potentially life-saving preventative services, such as mammograms and colonoscopies. These reforms for women not only make care more equitable, but they also help to reduce the cost of care by ensuring that many diseases are detected early or prevented before their onset through vaccinations and regular screenings. While additional reforms will be implemented in stages, many advances as a result of health care reform are already making a difference in the lives of women across this country. Thank you, and I yield back.
For what purpose does the gentleman from Pennsylvania rise? The gentleman is recognized.
Madam Speaker, on Sunday in a Yemeni city, Taiz, al-Qaeda terrorists viciously gunned down American Joel Shrum. Joel grew up in Lancaster County, Pennsylvania, in Mount Joy, and was a football star at Donegal High School, and he leaves behind a wife and 2 young sons who lived with him in Yemen. Joel worked as a teacher at the International Training Development Center, which focused on giving vocational training to the poor. Joel was a Christian, but he was not in the country to proselytize. According to his father, Joel was there to teach and break down barriers. The organization he worked for is staffed by both Christians and Muslims, and has worked in the country for over 40 years. The people of Yemen are appalled at this violence. Hundreds of activists took to the streets yesterday to demand justice for the killers. They carried photos of Joel and chanted, "Yemen is not a place for terrorism, and we love you, Joel." Joel Shrum selflessly served the poor in a country far from home. He'll be dearly missed by his family and by the people he came to serve. I yield back.
For what purpose does the gentleman from Virginia rise? Gentleman's correct. The House is not in order. The House will be in order. Members and staff are advised to take their conversation off the floor. And the gentleman from Virginia is recognized. Gentleman is recognized.
Madam Speaker, yesterday by 1 vote, the Republican Budget Committee passed a fend for yourself budget that gives Darwinism a bad name. It breaks a bipartisan compromise not even a year old. It voucherizes Medicare, in effect, jeopardizing health care for millions, tens of millions of American seniors. It essentially guts Medicaid, jeopardizing nursing home care for millions more. It block grants the safety net programs led by food stamps, threatening to reverse the progress, decades-old progress, in lowering poverty and malnutrition rates in America. This is a budget that needs to be rejected, Madam Chairman. It is a budget that would make Charles Darwin blush. I yield back.
For what purpose does the gentleman from Texas rise?
Madam Speaker, I request unanimous consent to address the House for 1 minute.
The gentleman is recognized.
Madam Speaker, the nationalized health care bill will soon go before the Supreme Court. The issue: does the federal government have the constitutional authority to force Americans to buy government-ordained and approved health insurance, or else face the wrath and punishment of government? The government does not have the authority to force citizens to buy any product, whether it is health insurance, a car, or a box of donuts. If the Supreme Court allows this government invasion of choice, what is next? If the government, under the guise it knows best, is it going to force citizens to buy only government-approved green cars, only government houses, only government food? The health care individual mandate is a denial of liberty. Yes, we need to fix health care, but does anyone really want to turn over the nation's health care to the government? The government seldom does anything better. And if you like the compassion of the IRS, the efficiency of the Post Office, and the competence of FEMA, you will love the unconstitutional nationalized health care bill. And that's just the way it is.
For what purpose does the gentleman from Texas rise?
To address the House for 1 minute to revise the
The gentleman is recognized.
Madam Speaker, I rise this morning to thank the many persons across the length and breadth of this country who have spoken up with reference to the injustice that has occurred in Florida, with reference to the young man, Trayvon Martin. I want to single out 2 people, however. The first, Joe Scarborough of MSNBC Morning Joe. When he spoke this morning, I literally had tears to well in my eyes as he took a strong position on this injustice. I beg that others would do likewise. I would also like to thank the Reverend Al Sharpton. He has lost his mother, and I, along with other people of goodwill, would like to extend our condolences and our sympathies. But I am so grateful to Reverend Sharpton. He has indicated that he will be at the rally tonight in Sanford, Florida, and I thank him for what he has done and is doing. May God continue to bless you, Reverend, and I look forward to being there with you.
Manil,
I would.
I'd like to proudly associate myself with your remarks.
Thank you, Mr. Chairman.
Gentleman's time has expired. Members are advised to address their comments to the chair. What purpose does the gentleman from Georgia rise?
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks and include extraneous material on H.R. 5.
Without objection. Pursuant to House Resolution 591 and Rule 18, the Chair declares the House and the Committee of the Whole House and the State of the Union for further consideration of H.R. 5. Will the gentlewoman from Michigan, Ms. Miller, kindly take the chair?
The House is in the Committee of the Whole House on the State of the Union for the further consideration of H.R. 5, which the clerk will report by title.
A bill to improve patient access to health care services and provide improved medical care by reducing the excessive burden the liability system places on the health care delivery system.
When the Committee of the Whole rose on Wednesday, March 21, 2012, all time for general debate had expired. Pursuant to the rule, the bill shall be considered for amendment under the 5-minute rule. In lieu of the amendments recommended by the Committees on Energy and Commerce and the Judiciary printed in the bill, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 112 through 18 is adopted, and the bill, as amended, shall be considered as an original bill for the purpose of further amendment under the 5-minute rule and shall be considered as read. No further amendment. The bill, as amended, shall be in order except those printed in House Report 112 through 416. Each such further amendment may be offered only in the order printed in the report by a member designated in the report, shall be considered read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and the opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. It is now in order to consider Amendment Number 1, printed in House Report 112 through 416. For what purpose does the gentleman from Georgia seek recognition?
Madam Chairman, I have an amendment at the desk.
And the clerk will designate the amendment.
Amendment Number 1, printed in House Report Number 112-416, offered by Mr. Woodall of Georgia.
Pursuant to House Resolution 591, the gentleman from Georgia, Mr. Woodall, and a member opposed, each will control 5 minutes, and the chair now recognizes the gentleman from Georgia.
Thank you very much, Madam Chairman. My amendment's a very straightforward amendment, but before I actually talk about the text of it, I want to speak about the real accomplishment of my friend from Georgia, who is the sponsor of the underlying legislation, H.R. 5. You know, Washington Times did an article on this Congress and called it one of the most ineffective Congresses in history because they looked at how many laws we'd passed. But then they went on and they looked at how many days of debate we'd had, how many votes we'd had, how many issues that were important to the American people have we been able to expose in this Congress that we have not been able to expose in Congress before Congress before Congress before Congress in the past. And, Madam Chair, that's what we have today. This bill, introduced by my good friend from Georgia, gives the American people an opportunity to discuss something that is on every single family's mind in this country when it comes to health care, and that is controlling the costs of medical malpractice litigation. Now, in this body, I'm sure we can disagree about the myriad ways there are to control it, but we can agree, I suspect, man and woman, Democrat and Republican, that it has to be controlled, and I thank my friend from Georgia for having the courage and the stick-to-itness to bring this bill to the floor after so many years of silence on this issue. Madam Chair, my amendment simply strikes the findings sections of the bill. As you know, findings are non-binding parts of the legislation that speak to the intent of Congress. And this issue that is, again, such a passionate one, not just for the 435 members of this House, but for the 300 million Americans across this country, I choose to let the legislation speak for itself. This legislation has been carved out with states' rights provisions in it to make sure that states have the flexibilities that they need. It's been carved out with the input of physicians, from attorneys, from families, from providers, all across the board. So my amendment, Madam Speaker, would not change the substance of the bill, but would simply eliminate the findings section to allow the substance of the bill to speak for itself. And with that, I reserve the balance of my time.
Gentleman reserves his time. For what purpose does the gentleman from Michigan seek recognition?
I rise in opposition to the Woodall Amendment.
The gentleman is recognized for 5 minutes.
I thank the Speaker. We're striking the findings. By striking statements of constitutional authority for the bill, the amendment recognizes that many members of the House question Congress's constitutional authority to pass H.R. 5. So for that reason, my colleagues, the findings are all important. Supporters of states' rights ought to take the next step and eliminate the section of the bill that preempts state law. Indeed, many supporters of the underlying bill have spent years arguing that decisions about health care are fundamentally prerogatives of the state. And so I have only 18 conservative or Republican scholars and leaders that agree with me, that include the Heritage Foundation, and I'll put all these in the record, the Virginia Attorney General, Mr. Cusinelli, the constitutional law professor at Georgetown Law Center, the distinguished senator from Oklahoma, Mr. Coburn, our colleagues, and I'm proud of Judge Ted Poe of Texas, our colleague from Nebraska, Lee Terry, former Judge Louis Gohmert in particular, Ron Paul, all of the founder of the Tea Party Nation, Judson Phillips. It goes on, where we are all in agreement that the findings are indeed critical and ought to be left in the bill. To take the findings out is incredible, because we say that the federal government shouldn't be involved. It's a state matter, and tort law is itself a state matter. So for those reasons, Madam Speaker, I am pleased to represent a bipartisan group of members and scholars that very strenuously object to the findings being removed in this Woodall Amendment. And I return the balance of my time.
Does the gentleman yield back the balance of his time?
Yes, ma'am.
Gentleman yields back his time. The gentleman from Georgia.
Madam Chair, can I inquire how much time I have remaining?
Gentleman from Georgia has 3 minutes remaining.
Thank you, Madam Chair. I yield myself such time as I may consume to...
Gentleman's recognized.
To say that as a freshman in this body, Madam Chair, I've had to learn a few things over 15 months here serving in this body, and what I've learned is that I haven't been able to get every bill that I want out of this House the exact way I want it when it leaves here. It's been much to my chagrin. I thought I was going to be able to come here and make every bill perfect before it leaves here, but not only can I not make it perfect before it goes, but then I have to deal with that United States Senate, and that's proved to be the most complicated part of this process. There are absolutely, as the gentleman has listed, folks who have concerns about the underlying nature of this bill. But if not for this Gingrey bill, we wouldn't be able to have this conversation at all. If not for the courage of folks to step out on the ledge and begin this conversation, we wouldn't be able to have it at all. If we are to advance the cause of litigation reform in this country, if we are to control the inaccessibility of health care that comes from rising costs, then we have to be willing to come to the floor of this House and have the kinds of debates that my friend from Georgia has made possible today. Now, it's true. I may disagree with some of the ways that we've gotten here. And then by striking the findings, we make no conclusions today about why we're here, but we make the certain conclusion today that if we don't begin this process, we will never bring it to conclusion. If we don't have this discussion today, Madam Speaker, we will never solve these issues. I'd be happy to yield to the ranking member.
I thank you for your courtesy. But why, as a new member as you are, and we welcome you to this body, why would we strike all the findings from H.R. 5?
They're reclaiming my time, and I thank the ranking member for his question, and that's a good way to conclude, Madam Chair. The reason is because the language of the bill speaks for itself. The language of the bill speaks for itself. When this bill passes the House today, Madam Chair, we will have the U.S. House of Representatives on record about solutions to the malpractice challenges that face this nation. But there is no need to be on the record today, Madam Chair, about all of the different ways that we got here. Because I might disagree with my friend from Georgia about how we got here. I would certainly disagree with my friend from Michigan about how we got here. But what is important is that we begin to take those steps forward, Madam Chair. And with the removal of these findings, we're going to be able to let that language stand on its face for this House to have the free and open debate that I'm looking forward to today.
Does it preempt state law?
Maintaining my time, Madam Chair, I would yield back the balance of my time.
All time having expired. The question is on the amendment offered by the gentleman from Georgia, and those in favor will signify by saying aye. Aye. Opposed will say no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. Gentleman from Michigan.
Madam Speaker, may we have a record vote on this amendment?
Gentleman's requested a record vote, and pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Georgia will be postponed. It is now in order to consider Amendment Number 2, printed in House Report 112 through 416. For what purpose does the gentlewoman from Oregon rise?
Madam Chair, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment Number 2, printed in House Report Number 112-416, offered by Ms. Bonamici of Oregon.
Pursuant to House Resolution 591, the gentlewoman from Oregon, Ms. Bonamici, and a member opposed will each control 5 minutes. The chair now recognizes the gentlewoman from Oregon.
Thank you, Madam Chair. My amendment to H.R. 5 simply requires the Secretary of Health and Human Services to submit a report to Congress detailing the effect that the tort reform provisions in this bill would have on health care premiums, and delays the effective date of Title I of the bill until that report is submitted. For years, proponents of tort reform have tried to convince Americans that skyrocketing health care costs are entirely attributable to greedy plaintiffs and runaway jury awards. They recite anecdotes about doctors closing their practices, refusing to deliver babies or perform surgeries for fear of being sued. But, Madam Chair, we should not be making federal policy based on anecdotes. If recent independent research is any indication, the report that the Secretary submits to Congress under this amendment is unlikely to find that the bill will have any meaningful effect on health care premiums. Recent analysis in states adopting restrictions similar to those in this bill has found no substantial impact on the consumer cost of health care, nor has access to health providers improved as a result. Proponents of tort reform claim that capping damages will drive down the cost of medical malpractice insurance and the doctors will pass this savings along to patients. But 2 years ago, the CBO found that malpractice insurance premiums, settlements, and awards account for just a tiny fraction of total health care expenditures. In 27 states where damages have been capped, medical malpractice premiums are not lower on average than in states without caps. My amendment asks for data on how this bill will affect the cost of health care for all Americans. Now, I want to be very clear. No one should be compensated for a frivolous lawsuit, but there are ways to address frivolous lawsuits without infringing on the rights of those who truly have been injured by medical mistakes. What this bill does accomplish ought to frighten anyone who believes in the rights of states to govern themselves and the rights of individuals to be compensated for loss. This bill tramples over the rights of states to enact laws governing their own tort systems, and it severely restricts individuals' rights to be compensated for all the losses caused by their health care providers. In my home state of Oregon, for example, our Supreme Court has held that most statutory caps on non-economic damages are unconstitutional. And Oregon's not alone. At least 12 other states have some constitutional prohibition against these types of restrictions. This bill not only overrides state laws and constitutions governing punitive and non-economic damage awards, it also addresses state statutes of limitations, pleading standards, attorney fee provisions, and joint liability. But it does not stop there. Although this bill is being presented as medical malpractice reform, it reaches far beyond professional malpractice against doctors to include product liability cases against drug and device manufacturers, bad faith claims against HMOs and insurance companies, and negligence suits against nursing homes. And it would take away all of these state and individual rights in far-reaching areas of the healthcare industry without evidence that doing so would lower the premiums for Americans. This is an unwarranted intrusion in personal liberty and a giveaway to insurance companies, so we should know if it's going to lower health care premiums. If this Congress is going to enact a sweeping bill nullifying long-standing state law and trampling on state constitutional rights, it's not too much to ask that we arm ourselves with the knowledge of how this will actually affect American families. This amendment simply requires the Secretary of Health and Human Services submit a report to Congress with that information before Title I of this bill takes effect, a reasonable requirement. I reserve the balance of my time. Thank you, Madam Chair.
Gentlelady from Oregon reserves the balance of her time. The gentleman from Georgia.
Madam Chairman, I rise in opposition to the Bonamichi Amendment.
The gentleman from Georgia is recognized for 5 minutes.
I rise in opposition to the Bonamichi Amendment because it would indefinitely delay critical medical liability reforms that will save American taxpayers tens of billions of dollars and save our health care system upwards of $200 billion a year in unnecessary spending. The amendment before us would delay enactment of the tort reforms outlined in H.R. 5 until the Secretary of Health and Human Services submits a report to Congress on the potential effects of medical liability reform on health care premiums. However, the amendment does not require the Secretary to produce a report by a date certain. In fact, the Secretary could simply choose to never issue a report and forever delay the reforms at the heart of this underlying bill. Regardless of what one thinks about H.R. 5, I do not believe it is appropriate to vest the Secretary of Health and Human Services with the authority to permanently block enactment of a law based on the inability to produce a report. I realize that there are some who might disagree because they would like to provide the Secretary with the authority under IPAB to unilaterally dictate the medical choices of seniors. Given the track record of this administration on liability reform and their failure to address the issues in Obamacare, HHS should not be given the power to bob and weave on this issue once again. I do find the amendment somewhat ironic, and I actually wish the author of the amendment was in Congress during debate over PPACA. Maybe if we had this type of amendment then, we would not be saddled with the law that is taking away people's health care choices and rising their health care premiums. We were promised that the law would reduce health care premiums by $2,500 a year. During debate on PPACA, we knew that that was not true, and the CBO told Congress that it was not true. What was common sense is coming to fruition now. The law has given us $1 billion new bureaucracy, and it's fueling even ever-increasing health care and premium costs. In this case, Madam Chairman, this amendment is not needed, but because we have seen that real medical liability reform can and will reduce costs. It will stop the vicious cycle of frivolous lawsuits in defense of medicine. It will make our health care system more efficient and will actually reduce unnecessary spending in the health care system, another thing the health care law failed to do. We do not need this amendment. With that, Madam Speaker, I will yield 1 minute to the distinguished Majority Leader, the gentleman from Virginia, Mr. Cantor.
Minority Leader from Virginia is recognized.
Thank you, Madam Chair, and I thank the gentleman. Madam Chair, I rise in opposition to this amendment, which would simply delay the implementation of what we know is a cost savings measure to so many millions of seniors and so many millions of Americans, not just seniors. Madam Chair, today we will vote to repeal one of PPACA's most harmful provisions, the Independent Payment Advisory Board. IPAB is emblematic of the two very different visions held by Republicans and Democrats about the path to quality care and how to control costs in our health care system. Madam Chair, the President and his party want a centralized board of bureaucrats to control decisions about how health care is allocated to our nation's seniors. He proposes to restrict health care choices in order to lower costs. Madam Chair, our American system of free enterprise, innovation, and ingenuity has made our health care centers the best in the world. Our doctors transform dire health care conditions into promising outcomes and healthy lives. We produce the world's life-saving drugs, disease prevention regimens, biologics, and devices. But IPAB hamstrings the best available care for our seniors by imposing artificial constraints, arbitrary constraints on cost. Neither the President nor congressional Democrats have proposed a solution to strengthen Medicare. Instead, the President gives 15 bureaucrats the power to make fundamental decisions about the care that seniors will have access to. Not to be deterred, the President has proposed expanding this board numerous times over the past year, vastly growing the board's scope and ability to fix prices and ultimately ration care for our nation's seniors. Madam Chair, the President and I do agree on this. The current Medicare reimbursement system is broken, but we do not need a board of unelected bureaucrats to control costs. As we have proposed today, there is a better path forward. During the health care debate, the President agreed with our nation's doctors that defensive medicine practices are driving up costs. Yet, meaningful medical liability reform was not included in the 2000-page health care law. Madam Chair, as my colleagues have proposed today, we can model medical liability reforms on state-based laws. California, Texas, and Virginia have all implemented working solutions that drive down the cost of care. We can even propose more creative medical liability reform solutions. We are always open to new ideas and suggestions, but not delay. Moving forward with common sense medical liability reforms will mean that doctors can continue serving patients. It means that injured patients will be compensated more quickly and fairly. It means health care costs will go down. Madam Chair, you don't need a new rationing board to save $3 billion. You simply need to enact liability reform policies that are so common sense in states like California and others that have had them on the books for decades. When the entire medical community stands opposed to an idea, I would hope that our colleagues on the other side of the aisle and the President would listen. Obamacare's IPAB is not the solution our seniors are expecting us to deliver. Our seniors deserve better. Madam Chair, I thank Dr. Phil Rowe, gentleman from Tennessee, Dr. Phil Gingrey, gentleman from Georgia, for sponsoring the PATH Act. I'd also like to recognize Chairman Fred Upton, Chairman Dave Camp, and Chairman Lamar Smith for working to strengthen Medicare for our seniors. Under their leadership, our House committees are advancing policies that will deliver the quality of health care the American people deserve. And with that, I'll yield back.
Distinguished Majority Leader yields back his time. The gentlelady from Oregon is recognized and is advised that she has 1 minute, 15 seconds remaining.
Thank you. And Madam Chair, I would like to yield 15 seconds to my colleague from Michigan.
Gentleman from Michigan recognized for 15 seconds.
Thank you so much. Just to get the facts into this debate, I rise in strong support of the Bonamici Amendment and ask unanimous consent to put into the record the Congressional Budget Office letter to Chairman Dreyer, March 19, in which the CBO estimates that enacting the provision would increase the deficit. Can I get 5 more seconds?
Yes, I yield 5 more seconds.
Would increase the deficits if you use IPAD by $3.1 billion.
Gentleman's time's expired and we're operating under general leave. Gentleman from Georgia.
Madam Chair, I respect my colleague from Oregon, and I know she's well-meaning and well-thoughtful, but I must oppose her amendment, and at that time I urge my colleagues to vote against the amendment, and I will reserve the remaining balance of my time.
Gentleman reserves. Gentlelady from Oregon.
Thank you, Madam Chair. This is a reasonable amendment. It simply asks that before we make sweeping federal policy that overrides state and individual rights, we know what we're getting in return. I urge my colleagues to support this very reasonable amendment. Thank you, Madam Chair, and I yield back any time.
Gentlelady yields back her time. Gentleman from Georgia.
Madam Chair, I yield back the balance of my time as well.
All time having been yielded back, the questions on the amendment offered by the gentlelady from Oregon. Those in favor signify by saying aye. Opposed say no. In the opinion of the chairs, the noes have it, the noes have it. The amendment is not agreed to. Gentlelady from Oregon.
Madam Chair, I would like to request a recorded vote.
A recorded vote is requested, and pursuant to Clause 6 of Rule 18, further proceedings on the amendment from the gentlewoman from Oregon will be postponed. The Chair understands that Amendment Number 3 will not be offered, and is now in order to consider Amendment Number 4, printed in House Report 112 through 416. For what purpose does the gentleman from Pennsylvania seek recognition?
Madam Chair, I rise for the purpose of offering an amendment.
Clerk will designate the amendment.
Amendment number 4, printed in House Report number 112-416, offered by Mr. Dent of Pennsylvania.
Pursuant to House Resolution 591, gentleman from Pennsylvania, Mr. Dent, and a member opposed will each control 5 minutes. The Chair now recognizes the gentleman from Pennsylvania.
Thank you, Madam Chair. I'm pleased to join my colleague Pete Sessions from Texas on the floor this morning in support of a very important amendment that we have introduced that would address the crisis in access to emergency care by extending liability coverage to on-call and emergency room physicians. The underlying bill we're debating here today is about patient access to care. Now, I recognize that ideology may divide the House on the underlying bill, but common sense should unite the House on this particular amendment. Our former colleague, Bart Gordon of Tennessee, had introduced this legislation with me last year. In this session, we have bipartisan support for this concept. Mr. Matheson, Mr. Langevin, Mr. Ruppersberger, all have co-sponsored this legislation that I am offering as an amendment. They co-sponsored the original bill. There's a growing shortage of physicians and specialists willing to work in emergency rooms. We've seen it all over the country. A 2006 Institute of Medicine report, The Future of Emergency Care, noted that the availability of on-call specialists is an acute problem in emergency departments and trauma centers. Emergency and trauma care is delivered in an inherently challenging environment. Every day, physicians providing emergency care make life and death decisions with little information or time about the patients they're treating. You know, I've spoken with surgeons who've told me they dread a code blue out of fear of lawsuit. They want to serve these people who are coming into these emergency centers, but are fearful for their families out of lawsuit. That's how bad. That's what medicine has become, unfortunately, because of this out-of-control litigation system. You know, as a result, these physicians providing emergency and trauma care face extraordinary exposure to medical liability claims. 40% of hospitals say the liability situation has resulted in less physician coverage for their emergency departments. According to a report from the GAO, soaring medical liability premiums have led specialists to reduce or stop on-call services to emergency departments. This trend threatens patients' access to emergency surgical services. Neurosurgery, orthopedics, general surgery are the most impacted. They also are the services that emergency departments most frequently require. Trauma centers across the country have closed. In my home state in Pennsylvania, this has been a very serious problem. This is an urgent issue that needs to be addressed. This amendment would protect access to emergency room care and reduce health care costs by allowing emergency and on-call physicians who deliver EMTALA-related services with medical liability protections. EMTALA, the Emergency Medical Treatment and Labor Act, ensures that any person who seeks emergency medical care at a covered facility is guaranteed an appropriate screening exam and stabilization treatment before transfer or discharge, regardless of their ability to pay. EMTALA is a federal mandate that protects all of our citizens, the insured and uninsured alike. This amendment will provide a backstop for the doctors who provide these critical services. Specifically, the amendment would ensure medical services furnished by a hospital emergency department, or physician or on-call provider under contract with a hospital or emergency department pursuant to the EMTALA mandate are provided the same liability coverage currently extended to community health centers and health professionals who provide Medicaid services at free clinics. This amendment will not impact the rights of individuals who have been harmed to seek redress. What this amendment will do is ensure medical professionals are available to provide critical, timely, life-saving, emergency, and trauma medical care to all Americans when and where it is needed. Please join myself and Representative Sessions in supporting this amendment. You know, if an accident ever happens to any of us, heaven forbid, we want to make sure that there are going to be people in those trauma centers and those emergency rooms ready to deal with us and have nothing on their mind but saving our lives, not worrying about lawsuits. So I urge adoption of this amendment. At this time, I reserve the balance of my time.
The gentleman reserves his time. For what purpose does the gentleman from Michigan rise?
I rise in strong opposition.
The gentleman is recognized for 5 minutes.
Thank you. To my colleague, Mr. Dent, hold up. You're giving complete immunity to hospitals, physicians, providers, for any emergency activity. Do you want to do away with all liability whatsoever because it's in an emergency room? Of course you don't. But this amendment requires the federal government to pay for the medical errors committed and denies our government any ability to address or reprimand those who commit medical errors. You don't want to do that. You don't want to go that far. The federal government would be responsible for all occurrences of negligence in an emergency room. Please, 98,000 patients die every year due to preventable medical errors. I reserve the balance of my time.
Members are advised to address their remarks through the chair. Gentleman from Pennsylvania.
Madam Chair, just very briefly, in answer to my colleague's comments, I want to say very briefly, this does not waive liability. It simply says that when care is federally mandated under EMTALA, that there will be federal liability protection provided to those who are providing the care. That's only fair. People still can bring action, but there will be federal liability protection, as there should be, because this care is being required under federal law. I think it's completely reasonable. At this time, I reserve the balance of my time.
Reserves. Gentleman from Michigan.
But what we're doing in the amendment is to provide immunity to all hospitals and physicians, and requires the federal government to pay for medical errors committed by them. Look, we have 98,000 patients dying every year due to preventable medical errors. I'm not slamming the docs and the hospitals. I'm saying that we don't want to provide complete immunity. This Dent Amendment, Madam Speaker, does just that. It provides complete immunity. And so I'm asking my colleagues to please slow down and realize that irreparable harm due to negligence in the emergency room, and we've got pages and pages of examples, would be not subject to adjudication because of this amendment. It's a very dangerous amendment. It goes way too far. It's overbroad, and I urge my colleagues to carefully examine the consequences of this provision. I reserve the balance of my time.
Gentleman reserves. Gentleman from Pennsylvania has 30 seconds remaining.
Yeah, the only thing I would like to say in response, once again, is this amendment only applies, the immunity protection only applies to care provided under EMTALA, and that's federally mandated care. Other activities going on in that emergency room or trauma center would not be given this exemption from liability. Only federally mandated care. Can't be any more clear. At this time, I reserve.
Gentleman reserves. The gentleman from Michigan is recognized, and he has 2 minutes remaining.
Thank you. Madam Speaker, this amendment would actually lower the incentive to practice safe medicine. And I say this on careful examination. I'm surprised that my colleague, the leader on the other side, himself a distinguished doctor, would be silent on this provision, because it shields hospitals, employed physicians, even physicians who are already covered by private insurance, and physicians working in an emergency room setting will never be held accountable when they wrongfully injure their patients. That is my only reservation and objection to what is otherwise a honorably intended revision of this measure. When hospitals and emergency room departments are not held accountable for medical errors and for negligence, then they have no incentive to offer quality care or hire competent physicians. Please, I beg you to carefully examine the dangers implicit in the Dent Sessions Amendment, and I return the balance of my time.
Gentleman yields back the balance of his time. The gentleman from Pennsylvania for his remaining 15 seconds.
Yeah, in conclusion, this amendment has bipartisan support. As I said, our former colleague Bart Gordon was a co-sponsor, introduced this bill along with me last session. Mr. Langevin is a co-sponsor of the bill, Mr. Matheson, Mr. Ruppersberger. It makes sense. This is important to make sure our citizens have access to emergency care should they ever need it. At this time, I urge support of the amendment. I yield back the balance of my time.
All time having been yielded back, the questions on the amendment offered by the gentleman from Pennsylvania, and those in favor will signify by saying aye. Aye. Those opposed will say no. No. In the opinion of the chair, the ayes have it, the ayes have it. The amendment is agreed to. It is now in order to consider Amendment Number 5, printed in House Report 112 through 416. For what purpose does the gentleman from Arizona rise?
Have the amendment at the table.
Clerk will designate the amendment.
Amendment number 5, printed in House Report number 112-416, offered by Mr. Gosar of Arizona.
Pursuant to House Resolution 591, the gentleman from Arizona, Mr. Gosar, and a member opposed will each control 5 minutes. The chair now recognizes the gentleman from Arizona for 5 minutes.
Madam Chair, I rise to address the House today in support of my amendment to H.R. 5 to amend the McCarran-Ferguson Act. This act exempts the business of insurance from many federal antitrust laws. In this modern day and age, it is hard to see why this exemption still persists. One of the original reasons to carve this exemption for the industry dates all the way back to 1945, was that insurance companies needed to share actuarial information in order to balance risk when setting premiums. However, since 1945, our federal law has evolved to include safe harbors to permit companies to share this data as needed. I believe that violations of antitrust law cannot always be dealt with on the state level anymore, as cash-strapped states lack the resources to enforce the law against these large, multi-state insurance companies. Therefore, it is time for this exemption to be repealed so that we can empower health insurance companies to compete more aggressively for the consumer dollar. Increase competition, increase insurance options, empower patients to a patient-centered system, and they decrease premiums. Therefore, we all win. Lowering the cost of health insurance is a goal we should all share, and that is why the House passed a very similar measure, H.R. 4626, with over 400 votes in 2010. There is one key difference between H.R. 4626 and this amendment, a difference of which I am proud. My amendment includes a prohibition on class action lawsuits in federal court against these health insurance companies. The FTC should have the power to investigate bad actors in the health insurance industry, but it helps no one if these companies, or for that matter, any American businesses, get mired in lawsuits that will cost millions. Class action lawsuits often result in big bucks in attorneys' fees for greedy trial attorneys, while leaving only pennies in the hands of plaintiffs who are allegedly wronged in the first place. For example, let's take the Cobell settlement. 15 years ago, a group of Native Americans sued the federal government and Secretary of the Interior Bruce Babbitt for mismanagement of their funds and won a $3.4 billion settlement, only to find out that their attorneys were petitioning the judge for over $200 million in fees. This is outrageous. When the poorest of poor are wronged in this country and are awarded a settlement in court, they shouldn't have to split pennies amongst themselves as their lawyers walk away with a big fat check. That is the spirit behind the tort reform piece of my amendment. I am pleased to see this House ready to pass a significant tort reform today and encourage all my colleagues to support my amendment as well as the underlying bill. Thank you again, and I reserve the balance of my time.
Gentleman from Arizona reserves. The gentleman from Michigan.
Madam Speaker, I rise in strong opposition to this amendment.
The gentleman is recognized for 5 minutes.
It is my position that within the good that this does is a poison pill. The good is the consumers would also benefit from a repeal of McCarran-Ferguson. We salute you. But the poison pill is that this measure would ban class actions on a claim for violation of antitrust law, which is the cleverest way of ending antitrust law. Unless you have a class action, my doctor, congressman, is not a lawyer, but without class actions, you can't bring a claim because nobody's going to file suit on a $30 issue. A million people suing for $30 each. So it's a poison pill, and I'd like to yield to the gentleman who had an amendment that had huge bipartisan support, Mr. DeFazio of Oregon.
Gentleman from Oregon is recognized for
as much time as he may consume.
as much time as he may consume.
I thank the gentleman. We had, at the end of the last Congress, a tremendous bipartisan vote, 406 to 19, on repealing straight up the antitrust immunity of the insurance industry. American people, no matter where they are on the Affordable Health Care Act, agree on one thing. Insurance companies should not be able to get together and collude to either exclude people from coverage or drive up prices. Yet they do. They have an exemption under a law from the 1940s. Now, what the gentleman is offering sounds pretty good, but it won't get us there because 90% of the antitrust cases are private. And almost every single one of those cases is a class action. So if you preclude class actions, you can pretend you're being tough with the insurance industry while you can wink and nod and say, hey, don't worry about it because they really won't be any litigation under this, and you're still going to be able to skate, and you're still going to be able to collude, you're still going to be able to drive up prices. And think of the context in what we're doing. We're talking about IPAB today, but they've already voted to repeal the entire Affordable Health Care Act. That means no more restrictions on rescissions, the dirty little practice where you've been paying your premium for years and you get sick and the insurance company says, sorry, we're not going to renew your policy. That's been outlawed. They're going to do away with the prohibitions on age discrimination. They're going to do away with the prohibitions on pre-existing conditions. So now we're going to have an insurance industry that is essentially free from antitrust law, that can take away your policy when you get sick, that can discriminate against you because you're old, can discriminate against you because you're sick or you have been sick, and it would take away the protections and the review of excessive rate increases. So if we were doing a straight-up take away their antitrust immunity, make them play by the same rules as every other business in America except for professional sports who are exempt from antitrust law, that would be fine. But let's not have this phony fig leaf so you can wink and nod to the insurance industry and say, hey, don't worry about it, it won't have any impact, but we can say to consumers we're with them. With that, I would reserve.
Gentleman reserves. Gentleman from Arizona.
We failed to realize that what we did here in repeal of the McCarran-Ferguson is the FTC, and the Department of Justice. Right now, privately, yes, you are right. Without the repeal of McCarran-Ferguson, there is more coming from the private aspect. But that's because we have limited the federal oversight and the FTC and the Department of Justice. This compromise is weighted very carefully to make sure that we get back to a balance, both federal and state, and does not oversee the state's rights as well. I reserve the balance of my time.
Gentleman reserves. Gentleman from Michigan.
Madam Speaker, I yield myself the balance of the time.
The gentleman's recognized.
We are here debating an overwhelming proposition offered by the gentleman from Oregon, Mr. DeFazio, which would have corrected this problem so beautifully. But now comes the poison pill, which says no more class actions. If you can't bring class actions in this matter, then there's no way people with small valid claims can go into court and sue for $30. Now, I think most people understand this without going to law school. If you eliminate class actions, you have effectively destroyed the McCarran-Ferguson repeal that we are bragging about. So it's a kind of undercover scheme. We pretend we're doing something good. We ignore DeFazio's overwhelmingly bipartisan supported provision, and we let the insurance company through. And they live to continue the vile practices that have been revealed and discussed in this debate. I reserve my time.
Gentleman's time's expired. Gentleman from Arizona.
Once again, I want to make sure that everybody understands that you are giving federal oversight